And Judge Bertucci is presiding, and we have David Lee, who is the Assistant State's Attorney, and we have Matt Davison, who is the Guardianship and Advocacy Attorney. We have the patient, we have the doctor, and we have the custodian, who are all going to be testifying. So with that, Bob, you can start, and you're all good to start?
And do you plan to do questions after that type of thing?
Yeah, I would think so, yeah. Yeah, I've got it like 5 written down.
All right, very good. All right, we are here for case number 2017, COMH 98765. As you know, this matter was up yesterday at the Daly Center at the Case Management Conference, May 8th at 11 o'clock. And the parties did bring to the court's attention yesterday that you would be presenting this agreed outpatient treatment order. So I had an opportunity to review that yesterday, and you've not indicated there are any changes to it, corrections or amendments?
There are no changes to it, Your Honor.
All right, it appeared to be in order yesterday, so I have that. In addition, I did read Dr. Zarif's psychiatric report about the patient, his recommendations. My understanding is that you plan to call Dr. Zarif briefly. Unlike a trial that may involve an hour or more on the witness stand, you're briefly going to put him on, ask some questions, is that right?
That is correct, Your Honor.
And as well, the custodian?
Yes, Your Honor. The custodian is Renee Tate.
Okay.
She's the custodian for the purposes of this agreed order. She's a custodian for the respondent.
All right, will you be calling Dr. Zarif first?
Yes, Your Honor.
All right, I'm going to ask you to stand briefly, Doctor. Please raise your right hand. Do you swear or affirm that the entire testimony you give us today is the truth?
Yes, I do.
All right, very good. Thank you, Doctor. You may inquire.
Thank you. Doctor, would you state your name and spell for the court?
My name is Shabir Zarif, S-H-A-B-B-I-R, last name Zarif, Z-A-R-I-F.
Do you know a person by the name of John Johnson?
Yes, I'm his treating psychiatrist.
And how long has Mr. Johnson been here at Madden?
John was admitted on March the 1st to Madden Mental Health Center in Pavilion 2, and I've been his treating psychiatrist since then.
Did you have an opportunity to review the medical records for Mr. Johnson?
Yes, I have.
Is there a history of noncompliance to medication treatment?
John, yes, does have a history of noncompliance with medications, and since he's come in this time, we've had extensive discussions, and he's agreed to, he's understanding that he needs treatment as an outpatient, and he's willing to continue with the help of this agreed order.
And is there an indication in the medical records that he has been hospitalized multiple times in the year prior to his current hospitalization?
Yes. This is John's 6th state hospitalization since his illness began about 5 years ago. Since then, each hospitalization has sort of preceded by a few weeks or months of non-compliance. He gets emergence of symptoms and brings him back to the hospital.
Currently, is he receiving medication treatment?
Currently, John is receiving treatment. He had not agreed to take any medications for the first few weeks, but now he is willing to take medications, and he's doing very well.
And did you have an opportunity to discuss with the respondent some of the side effects and the benefits of the medication that you're willing to enter into?
Yes.
What are some of the medications that you have discussed with him?
So currently at this point, John is taking Risperdal 2 milligrams every night, takes it orally, along with Trazodone 50 milligrams, again orally, which helps him with sleep. Those are the only medications he's taking now.
Has any side effects been reported with the use of those medications?
John doesn't report any side effects. We've not witnessed any side effects. We've done the appropriate labs, and they've all been within normal limits.
What is his diagnosis?
John's diagnosis at this time is schizophrenia paranoid type.
Is he ready for discharge at this point?
Yes, his symptoms have resolved. Both the positive and the negative symptoms have resolved. He's doing much better. His affect is calmer, and he's interacting in groups. We've had family sessions, and they've gone very well. And we do believe that John is ready for discharge.
And it is your opinion, doctor, that he needs ongoing treatment post-discharge?
Yes, the treatment of schizophrenia does require, especially with multiple hospitalizations, ongoing treatment.
Is the outpatient program the least restrictive setting appropriate for him at this time?
Yes, at this point, John has improved and is ready for discharge.
Nothing further, Your Honor.
Do you have questions, Mr. Davidson?
Just briefly, Doctor, my client's been very articulate about his inability to remain compliant once he's been discharged from prior days. Is it your belief that with this order entered, it'll help keep him compliant based on the history of the non-compliance without an order?
Yes, I do believe that is correct. John has explained, and we've had sessions where he says, I feel better, and when I feel better, I feel I don't need to take the medications anymore. So if there's an added incentive, added supervision from the court, that would help him stay in compliant, and that would prevent hospitalizations.
Thank you, Doctor. Thank you, Judge.
All right, thank you. Based on your questions, I don't have any questions of the doctor, so thank you, doctor. Thank you.
The state calls Renee Tate.
All right. Please, while standing, raise your right hand. You swear or affirm that the testimony you give today is the truth?
Yes, I do.
All right, thank
You may proceed.
you. You may inquire.
Thank you, Your Honor. Would you state your name and spell for the court?
Renee Tate, RENEE-TATE.
And what is your occupation?
I am an ACT supervisor at Community Counseling Centers of Chicago.
Do you know an individual by the name of John Johnson?
Yes,
Who is he to you?
he is one of our clients.
Now, are you here to act as the custodian for the respondent in this outpatient treatment program?
Yes,
Do you know what your duties are?
yes.
What are your duties?
So we will be providing outpatient services, which consists of medication management. We will also be providing case management, as well as he will be meeting with our psychiatrist and a therapist as well.
Nothing further, Your Honor.
Do you have any questions?
Yes, Judge. One of my client's concerns is that once he's in the community, he does not have a driver's license. So one of the issues he's had in the past is his ability to get to appointments or to get to therapy. And one of the reasons for him agreeing to enter this agreed care and custody order is the expectation that your agency is going to provide transportation to these various things. Is that correct?
Correct. We provide transportation to medical appointments. We will also be providing transportation to our therapists and our drop-in center, as well as for case management services as well.
Okay, and as far as medication management goes, these are daily medications for psychosis. So how does your agency make sure that he's managing his medication correctly?
So we will be meeting with him at least 5 times a week, and each time we will provide him with a bubble pack, which will have his daily medication. We will also be checking in with him and his family.
Thank you. I have nothing else, Judge.
All right, I do have a question for you. You do understand that if a respondent fails to comply with the conditions of this agreed order, you may arrange for his admission to a mental health hospital.
Yes.
Do you have any questions about that or anything you've talked about here?
No.
Okay. Anything else?
Nothing further, Your Honor.
No,
Thank
Judge.
you.
The state rests, Your Honor.
All right, Mr. Davidson.
Judge, Mr. Johnson's here. He's indicated to me he's more than open to have a dialogue with the court about his expectations with entering this agreed order today. He's very excited about this. This is a new opportunity for him. Both parents are in the community right now. He'll be living with them. I had the opportunity yesterday to review the draft agreed order with him in private. He asked very cogent questions about some of the terms, and it's his understanding that if he's not compliant, he risks being brought back to Madden or another state facility and checked in as voluntary. He's excited about this opportunity and appreciates the opportunity to participate in the order.
All right, very good. This is something that you do agree to?
Yes.
All right. Do you have any questions of the court about it?
No.
All right. And it does include medications, 2 medications the doctor talked about, and you're taking those now?
Yeah, the Risperdal and Trazodone.
Okay. Any problems with those at this point?
No.
Okay. So we expect you to continue with that per the doctor's really prescription and per the agreed order, and you understand that?
Yes.
All right. And what we're going to be doing is giving status dates, if I enter this order, and I expect to, frankly, based on what I've read and what I've heard today, and I'm excited for you as well about this. But I will give status dates, and I'll be getting reports from your attorney, the state's attorney, from, custodian about your compliance, so the court will continue to monitor it, even if I don't necessarily see you, because I don't want to disrupt your appointment schedule or things like that. But if need be, we will have you brought back to court. So you're familiar with that?
Yeah, my lawyer explained that to me.
All right, and he will continue to be your attorney, so that if there are things that develop, maybe modification of the order needs to take place in terms of the medication or something else, your attorney can petition the court, bring it to the court's attention. Your custodian can do that as well. Do you understand that?
Yes.
All right. Anything else by either side?
Nothing further, Your Honor.
No, Judge, thank you.
All right. Well, as I've indicated, I did read Dr. Zarif's psychiatric report. I also read the petition, the attached certificates, the agreed care and custody order, which was provided to the court yesterday at the case management conference. And based on everything, having heard from the witnesses today, the court is satisfied that the recommendation is both in your best interest and the best interest of the public. Personally, the court's very fond of these orders. I've had great success with them over the years. Not frequently enough, unfortunately, but it seems like that's picking up a bit. Even attorneys involved are trying to identify cases that fit this program, and it appears you certainly do. So I'm excited for you, and as I said, I think it's not just in your best interest, but the best interest of your family, the public as well. And the hope is that this sort of revolving door that you're familiar with, you get out, things go well for a little while, but then you end up back, will end, and you'll get the outpatient treatment that otherwise isn't always happening, because there'll be a custodian to stay on top of it, your family's on board about it, and as I said, your attorney continues to represent you, so that if you need a sounding board about anything, those individuals are available to you. You do understand that?
Yes.
All right, with that, I will sign the agreed order.
Thank you, Judge.
Thank you, Your Honor.
Thank you both. My time on the bench, I've maybe had anywhere from a handful to possibly 9 or 10 of these. So not as many as the hundreds of trials I've probably had. And that's really unfortunate. So I hope that we continue to identify cases that fit with this. It saves, first of all, it is a benefit to the public, to the respondents. It also saves doctors' time, hospital time and expense, social workers, etc., entering these orders. There's just so many benefits to them. And of those that have done 10 or less, I've only had one person immediately take off. He was actually a med student or a resident with mental health problems, and I think he went back to his native country, somewhere in the Middle East. But other than that, everyone else has complied, and it's been very successful.
So I'm going to run through some of the most common questions we get when we're on the units or when we're giving presentations, especially for the benefit of any treaters watching this video, that you're going to have some just common questions that come to mind. So we're trying to anticipate those. I'm going to run through kind of the top 5. If you have any kind of follow-up questions, or if I'm not being clear, I would really invite you to raise your hand at the end and kind of follow up, or just kind of ask me to clarify something I'm making. Probably one of the most common questions we get is, if this is an agreed care and custody order, do we really need the treater to come? Our psychiatrists at these facilities are very busy, they're inundated with work, do they really have to come over? Well, hopefully, as you've just seen, these are relatively very short proceedings. The answer is generally yes. For the court and the judge to feel comfortable agreeing to enter this agreed order, they're going to want to hear from the doctor about the medications in particular, and why this is not only in the best interest of the respondent, but it's also in the best interest of the public. Additionally, the sentiment behind an agreed care and custody order is that it's a show of support, and it's kind of a team unified effort to these individuals. They're seeing that the custodians here, the treaters here, the attorneys here, and the judges here too, and everyone's kind of getting behind them to have this agreed order entered. Another question we get is, how does the hospital actually get their case on the court's radar so the court can actually enter this agreed care and custody order? As most of you know, the typical route for filing a general just petition for involuntary is you call the clerk and you do the fax and things like that. That's just what you're going to be doing here. David Lee, the Assistant State's Attorney, is very good about providing the petitions and the form and the boilerplate work that you need to get done, as well as the certificates to get filed in. If you call the clerk and you start using words like outpatient, which some of you have, the clerks get a little confused, or they sometimes think that maybe you're calling the wrong thing. So when you call, just say you're calling in with a petition for the state facility, and they'll know and put it on the docket. Once that happens, it's assigned a case number. We're all triggered. David then knows about the case. I also know about the case. Hopefully you already do because about the referral. But now the court knows about the case. If it's coming in from Madden, it's going to be put on the Wednesday case management call. So now the judge says, well, what's happening with this case? Is it going to outpatient? Is it by agreement? If it's done through Reed, similarly, it'll be put on the Thursday case management call. So that's the best way to get it on the court's radar. You can also just get it on our radar when I'm visiting the units and you say, I think I have a good outpatient candidate for you. And then, as you guys know, I start bugging you to get the petition on file so we can get the agreed care and custody order entered. The third most common question we get is, okay, we have the petition filed, we have the certificates filed, is there anything else that should be filled out prior to the court hearing in the agreed order? As you saw during the demonstration, we're also going to want to have provided to the court and the parties the written report by the physician. They're going to have to go through this kind of boilerplate language in the statute about the respondent's social history and things like that. You do not have to come up with a report from scratch. Again, David is very good about providing the template for what the treaters are going to need to fill in. It is not a book report. It's not this 50-page thing. It's generally a 1 to 2-page summary to apprise the court of the respondent's background so we can ensure that this is the appropriate measure to take. One question I actually really like getting when I'm pushing on psychiatrists to move forward with these is the treaters are generally just concerned about how can the doctor feel comfortable that the respondent is going to be compliant once they're discharged, that they genuinely care about these respondents and they're worried about whether a week or two from now nothing is going to be done to comply with the court order. One of the great things the court is doing, and you'll see through the demonstration, is that they will ensure that the custodian understands that it's not just the respondent making this promise by the agreed order, it's the custodian as well. They've got a job to do, they've got medication management, especially from the outset, the first few weeks. C4, HRDI, they're going to these respondents' homes on a daily basis with the medication. So it's a very hands-on community treatment thing to make sure there's compliance. If there's not, there are remedies in the order already. The custodians can come to court on the next status date. They can tell the attorneys. If they're really upset, they can come in to modify the order or even bring the respondent back to the hospital and have them admitted as a voluntary if there's true noncompliance. So a treater at a state facility should feel comfortable with this order because there are remedies already built in for noncompliance. The fifth question we get is, what's the target population? Who are we looking for on these units? Who's available? Who's going to qualify for purposes of having these orders? And the great answer is that it's across the spectrum. You're going to have individuals at these facilities that are voluntary, that otherwise meet the criteria and would be great outpatients. You're going to have people that just got back from a med petition for treatment and they're being ordered to take medication, and after 2 or 3 weeks you're going to see that this person's a really good fit for outpatient treatment. The last point is the threshold requirement. Is, well, what is the burden here? What are you going to have to prove as a petitioner to proceed? And you should know that the outpatient threshold is slightly different than an inpatient, meaning it's less. It's a much, I hesitate to use the word friendlier, but it's a different type of standard, so it's a much more comfortable statute to proceed on about if they are in the community and they're going to be deteriorating. So all of those points, have I not touched on a common question that's coming up at the units or with you?
The most frequent question I get is some version of this. There's no teeth in the law, and so how do I know it's even going to help the patient? And I say, well, where we've used it in Southern Illinois, because our 2 Southern Illinois hospitals, we have very good reports on how helpful it is. And then, of course, you hear, well, Southern Illinois is different. I don't think it's really going to help up here. So I was interested in what you would say to that and what you would say, Judge, because you've had some experience with this, and I was glad to hear you say that it was in fact helpful. So give us some language to help, because I get those questions every time I talk about it.
You know, I think there is something to be said about the power of the robe, about having someone come and participate in agreed care and custody order, that it isn't just another discharge, that there is some power of having a judge participate in the hearing. And quite frankly, with all the current clients we have now, they take it very seriously. They take the reporting in very seriously. And there are teeth. I think Choate is a great example that you brought up, that they're passing this with flying colors. I think they're doing a great job. The idea with noncompliance is that, unlike some other states, our courts are very hands-on in the sense that they don't say, come back at the end of 180 days and let me know how it went. As you see, especially Judge Bertucci will set a very short date upon discharge to say, okay, was discharge smooth? Are they immediately stopping the meds? What's going on here? Because if not, they're coming in and they're explaining why, and if not, we're going to take it a step further than that.
So we do have built in this, and respondent understood, and so did custodian, that they're going to be back as a voluntary. That's hanging over their head, certainly. But I do tend to set very short status dates. Now, if next Wednesday didn't work for the lawyers, I would have gone to the following one. But I like to set a very short one, because typically they've been released by then, they've got their first appointment by then. And it's not disruptive to them because I'm not asking them to be there.
Okay, so the question is, how do we, if you're not in contact with the custodian, because you have other files to work on, how are we making sure the custodian, how do they make sure they're taking their medication?
I guess they were saying that they would go to the house 5 times a day and make sure that they are taking medication.
5 times a week.
5 times a week. But in order for us to really know if they are taking it, we have to observe them taking the medication.
Yeah, so my understanding from C4, especially at the last agreed hearing we had last week, is that they're actually showing up on the doorstep with these daily packets and medications being compliant on the doorsteps or in the home at that moment.
Because sometimes the dosage is twice a day, thrice a day.
Right.
Sometimes it's in the morning, sometimes it's at night. So would they be going at those times?
For C4 and HRD, where's Shantae at?
She's
Yeah,
there.
there she is.
Formerly known as
So
Red.
I can speak from outpatient, I've done outpatient treatment before, but basically what happens is, you're right, usually they'll try to go in the morning, make sure they have their daily medication. If there's evening medications that need to be administered, they'll usually either, if they're with family, they'll connect with family, or they might call and check in, so, and there's also a crisis line as well. But typically, they're going to be around more than likely in the morning to make sure at least they get that administration of it.
To the timeline as to when the orders, petition is first filed and the order is actually going to be written. Because sometimes that's a concern as to the patient is now ready, how much longer is the patient going to be?
Yeah, sure, that's a great question. That actually should be on the list of the most frequently asked questions, is that we came around to Madden and Reed and talked this up, and you guys were great about making the referrals right away, and then it was, well, why is my person still here if I made the referral on Monday and it's been a few weeks later? So the answer is it's a variable, it's a moving target in the terms of if that person has a residential placement lined up, if we're talking about someone that has mom and dad in the community, a place to live, they've got money, you're going to see a much quicker resolution to that petition. We had a petition last week filed on Tuesday, and I think we entered the order on Thursday. But that was because the person had family in the community, there wasn't an issue with funding and things like that. So as you go down that list, if the person's homeless, which we know a lot of the population here in Madden is, and we're going to have to ping different resources to make sure they have residential placement, that will take longer. I will say, at least from our end, thankfully, so far, the holdup has not been on the court's end in the sense that the judges and attorneys are clearing their schedules to get these entered. It's more about the practical concerns of, well, where are they being discharged to? Are they on benefits yet? And things like that. So that generally takes a little longer to get in place.
And the social workers have been very helpful with that.
Yeah, absolutely.
I mean, Matt.
Is it expected that the patient has benefits before they go to court?
So the question is should the patient be on benefits before we enter the agreed care and custody order? Based on experience with several cases by now, the applications have been quote-unquote pending and not yet gone through, and the community providers have indicated they're willing to kind of take the ball and run with it while those are pending, whether it's either Medicaid, and we know Social Security takes much longer, and so we're trying to develop a quicker way to run through those, and there's different ways to get the certifications to get the SS pushed through. But if the Medicaid's pending or on the way, we have not received any resistance from the community providers about, well, we can't really participate as custodian because we got to make sure we have our money coming in. They've been instructed just to march on, which I'm happy to report.
If you think someone is a possible outpatient order, I would encourage you to file, okay? Just because it's filed doesn't have to go to hearing in 2 days or a week. It can get continued. Because what I was hearing was happening is that everybody's waiting till everything's all teed up and ready to go, and by that time the patient decides to leave. So I would encourage you to file them when you think they're ready, and then go to hearing when you're ready, because otherwise we're scrambling to get it to hearing as soon as we can. And the second thing is, even a patient who is discharged, you can file an outpatient, a petition for outpatient treatment against someone who's going to be discharged. Say they've been here for a month and they sign a voluntary. You can still file that petition.
Yeah, so it doesn't have to be all or nothing, and that's what has tended to happen when we didn't have so many agreed outpatient orders entered. Rather, we had, treatment petition filed, it was either granted or denied. I would tend to think, at least the ones I've had, most of them are granted. And then the person gets better in a few weeks or so, gets released. You hope they follow up with that appointment, but there's really, in those instances, it seems no teeth at all. And then they're back, and that's what the history of this respondent was, because it's based on a real scenario. Maybe 5 hospitalizations, release, problems, come back in, release, problems, come back in. We hope to, eliminate that sort of all or nothing approach, meaning, secured locked facility or free on the hope that you'll do the right thing now that you're better and ready to be released. We want to end that cycle, quite frankly. And as I've said, I've probably entered about 10, and one person took off right away, but all the others worked. And I started to mention the one where, and these were, outside the grant. Father was custodian. He would report to court for statuses. I started to extend the status dates to be 3 or 4 weeks apart, but at the beginning I set the first one in a week, the next one in 2 weeks, because the respondent, just petrified his mother. The parents were divorced, and actually, was caught with weapons and threatened to kill her, and a young man. But father, who he lived with, the parents were divorced, was the custodian. He would report to the court. The person was taking college classes, going to his appointments, and had a strong musical interest, so pursued that as well. And that's been one of the great success stories, really. So again, it wasn't under the grant, but it was an agreed outpatient order that worked out very well.